Welcome to the Explainer, everyone. I'm Amr, and today I'm here with my law student, Bisma. We're diving straight into Chapter 2 of Family Law Litigation Simplified. We're talking jurisdiction, constitution, and the true character of the family court. You ready for this, Bisma?
I am so ready. Lead the way, Amr. I know this is a highly specialized area of law, so I'm really eager to see how all these pieces fit together in the real world.
So let's start with a cold open question right off the bat. What if a husband and wife just agree to use a standard civil court for convenience? Like, say they want to bypass the family court entirely and just file a regular civil suit.
Yeah, absolutely no way. The law strictly forbids that kind of forum shopping. The Mohammed Nawaz 1985 ruling is crystal clear here. A civil decree in a first schedule matter is literally a complete nullity. You just can't consent your way out of it. Standard civil courts are completely stripped of their power here.
Okay, good to know. So who actually runs these specialized courts then? If civil courts can't touch this, the judges must have some serious specific authority backing them up.
Exactly. Under Section 3 of the 1964 Act, the High Court formally appoints qualified district, additional district, or civil judges to preside over family courts. They're established specifically for these sensitive matters, operating right there in each district.
Right, that makes perfect sense. But what can they actually hear? I mean, we know it's family issues, but how is that strictly defined in the law?
So that brings us straight to exclusive subject matter jurisdiction. The law doesn't just generically say family matters. It gives a very strict, exhaustive statutory list of what falls under their domain.
Specifically, Section 5 grants exclusive jurisdiction over 7 exact first schedule matters. We're talking dissolution of marriage, dower, maintenance, restitution of conjugal rights, child custody, guardianship in some provinces, and dowry recovery. If your claim isn't on that specific list, it's just not getting in.
Wait, so does that exclusive list include recovering dowry articles and wedding jewelry? Because property disputes can definitely blur the lines between standard civil law and family law, right?
For sure. The 2016 Supreme Court ruling in Kulsum versus Federation confirms this perfectly. All property claims stemming from a marriage stay exclusively right here. Wedding gifts, dowry articles, the family court handles the whole shebang.
Okay, but on a practical level, where does a separated wife actually have to file? Does she literally have to travel all the way to her husband's district? That sounds like a massive logistical and financial hurdle.
Well, here's where it gets really interesting. There's a deliberate practical advantage built into the law specifically for wives. They get a special territorial exception. They can file exactly where they reside today, at the time of filing. The jurisdiction is tied entirely to her current location.
And the 2005 Fauzia Bibi case firmly backs this up. The husband must travel to her district. He absolutely cannot compel her to transfer the case to his jurisdiction just because it's easier for him. The law actively protects the wife from geographical harassment.
Wow, that's incredibly protective. So once they're actually inside the courtroom, is the family court judge just sort of sitting there passively waiting for evidence like a standard civil judge?
Actually, no, not at all. Under Section 12, these judges have a really powerful inquisitorial character. They aren't just passive umpires. They can actively summon witnesses and demand documents entirely on their own motion to get to the absolute bottom of the truth.
Okay, but how does that inquisitorial power actually play out in a real practical case?
Amr, take the Razia Sultana ruling from 2008. If a husband claims he has zero income to avoid paying proper maintenance, the judge doesn't just nod and accept it. They must actively call his bank statements to expose his true financial reality.
That is a real game changer. Let's pivot to dissolution for a second. Can a judge just fast-track a divorce if both parties are obviously completely done and just want to skip reconciliation entirely?
Absolutely not. Section 10 outlines a strictly mandatory procedure. The judge has to genuinely attempt reconciliation, officially record the failure of that attempt, and only then frame the issues for trial. It's a strict statutory requirement. You cannot just casually waive it.
And the Shahida Perveen ruling really hits the nail on the head here. Skipping that officially recorded pretrial reconciliation is a material irregularity. It literally invalidates the final decree. The court has to show on the record that an active effort was made to save the marriage.
Okay, here's a tricky hypothetical for you. What if a wife files for custody in the family court, but the husband simultaneously files for guardianship in the standard district court under the Guardian and Wards Act? You've got two competing forums now.
Right, so in those parallel situations, the two courts absolutely have to coordinate. Ordinarily, the standard district court must pause. It should systematically stay its proceedings and defer entirely to the specialized jurisdiction of the family court. As the Supreme Court laid out in the 2010 Khalid Mahmood case, the welfare of the child demands unified adjudication. The family court gets to decide first, keeping all these deeply interconnected disputes under one specialized roof. No procedural chaos allowed.
That is such a brilliant breakdown of the procedures and the philosophy behind them. So to wrap up this highly specialized framework for anyone watching The Explainer right now, what is the ultimate takeaway here?
Master these strict rules. The family court is this incredibly powerful, protective, specialized forum, completely devoid of all that traditional civil court baggage. Navigating it properly is the absolute key to delivering real justice in Pakistan. But, it does make you wonder. What happens when this powerful court, with its active, inquisitorial mandate, oversteps its own boundaries? Well, we'll leave that provocative question for next time.